Welcome to the Garrulous Gavel. I'm John Tico. In this episode, I interview Jason Rathod, an attorney who has written academically about how the United States uses foreign aid in order to impose our legal system on other countries. Jason argues that in doing so, we only impose the parts of our legal system that are pro-big business, and we leave out the parts that are intended to protect consumers and employees. You'll hear why Jason advocates for what he calls aggregate litigation mechanisms, such as class actions, to fill that void. We'll also get garrulous with Jason about his very unique destination wedding, which included a traditional Indian wedding processional through the streets of Cartagena, Colombia, featuring a dancing Jason on top of a horse-drawn carriage. I think you'll really like that story, as well as the rest of this very thought-provoking interview. Welcome to the Garrulous Gavel. I'm John Tico, and my guest today is Jason Rathod. Jason is a lawyer whose practice focuses primarily on representing plaintiffs in class action litigation. I think you do mostly sort of fraud and product defect type cases. Is that right?
That's correct.
Well, welcome to the podcast.
Thank you, John. Great to be here.
And Jason is not only a practicing lawyer, but he also has a bit of an academic bent and has written a number of quite lengthy, detailed law review articles in which he discusses how the U.S. legal system compares to legal systems in other countries, particularly in how they handle what Jason calls aggregate litigation, basically cases that are intended to resolve the claims of large numbers of people, often consumers or employees of big companies, all at once. And today we're going to be talking to Jason about a very important topic. Among the many things that the U.S. exports to other countries around the world is our legal system. And one way that we do that is by tying foreign aid to legal reforms in countries that are receiving that aid. And this raises a number of interesting questions about whether we should be doing that, how we do it, and importantly, which aspects of the U.S. legal system we should or should not try to impose on foreign countries. And Jason has done some deep and heavy thinking about those issues. And so we're going to be hearing Jason's views on that and talk to him about that interesting issue. And then, as usual, we're going to end with something a little bit lighter. We're going to be talking to Jason about his world travels. He's been to many, many countries around the world. But most significantly, he and his wife planned and executed a destination wedding in a foreign country that neither of them had ever been to. And that destination wedding involved a traditional Indian wedding processional through the streets of a city in the nation of Colombia.
Yes.
A place that had probably not seen too many of those before. So we're going to be hearing that fun story towards the end. So let's start, as we normally do, by learning a little bit about our guests. Jason, where did you grow up?
Yeah, John. So I grew up in central Nebraska, primarily a town called Hastings, Nebraska. It's about an hour and a half west of Lincoln.
And you lived there your whole childhood?
Yeah, pretty much. Just there are a few other small towns in the area, but that general area is central Nebraska.
And was this a small town or a big town?
Yes, it's a town of about 25,000 people.
Is this a sort of a rural area of Nebraska?
It's pretty rural, yeah.
And so like how was that for you growing up?
Yeah, it's, as you said, it's really rural. It's kind of, the town is nestled in cornfields. And it was a great experience. I mean, you have a lot of freedom. It's very safe. So I grew up kind of a typical Nebraskan kid. I was in many ways a jock. I loved Cornhusker football. I played a few years of football in high school. I was also very much a Nebraskan nerd. I was on the debate team. I was on newspaper staff. So got kind of the full experience.
You had all of the high school social circles covered.
Exactly.
You were both a nerd and a jock at the same time.
Totally. And my dad was also a pastor in in the town. So, I was sort of the son of a community leader, which brings its own interesting elements.
Yeah, like what?
Yeah. So I would go to church twice a week, on Sundays and Wednesdays. Sundays for Sunday school, church, Wednesdays for Bible study. But growing up kind of as a quasi-public figure, son of a quasi-public figure, you learn early how to glad hand people, and also a lot about public speaking early and how to present yourself. So,
oh, that's interesting. And do you think that has kind of stood you well in lawyering?
I think so. Those are all good qualities to have as a lawyer, for sure.
Did you know, sort of growing up, that you might end up in law, or did that come later?
That came later. I had always aspired to be more in the policy realm, or potentially a politician. I did have some thoughts maybe to enter the ministry myself when I was younger. And law, it kind of came along the way. I thought if I want to be in policy, maybe I should go to law school. Mm-hmm. Didn't work out that way. I gave practice a try. and a different...
Yeah, we could talk about... I mean, it's not totally distinct, right? I mean, you're still doing a type of law that has a policy aspect to it.
Absolutely.
Yeah. So after you graduated high school, where'd you go?
Then I went to Grinnell College, which is about 5.5 hours away in Grinnell, Iowa. Also a very rural setting, but couldn't be more different culturally in some ways. So it's a small liberal arts college, about 2,000 students, known for being kind of a hippie, very progressive place.
And that was culturally different because why?
So where I grew up is very conservative, I want to say. Politically, they, I can't remember if a Democrat has ever been elected from our congressional district. Mm-hmm. And then I think, just in terms of diversity, my hometown is about 95% white. 5%, the other 5% is primarily immigrants from Mexico, maybe, a few others, including my family, are immigrants from India. And Grinnell it has students from all over the country, all over the world, really. And it's also ideologically, as I mentioned, very, very different.
And did you feel that difference when you got there? Was that like a surprise or a shock to you in some way, having sort of grown up in a sort of more rural conservative area?
I knew sort of what I was getting into, but there are shocking things you see there you're just not used to. Yeah. People appear very differently. Everyone's kind of clean cut where I grew up. But also just, I think one of the harder things is to adapt to how people talk or think about things. So sort of the baseline in rural Nebraska is that everyone is Christian. Everyone, has sort of certain a spectrum of ideological views, and you're kind of angling and pitching things within that when you're discussing issues or grappling with that. And at Grinnell, it's just completely wide open. You can't have those same bases. If you're trying to talk about an issue like, say, gay marriage, and you quote something from the Bible, you kind of get a weird look from people at that point. So I think it's a pretty disruptive transition in that way.
So I know, one of the things we're going to talk about a little later is some of your world travels, and you've done quite a bit of traveling. Had you done any of that before college, or was that all things that came later?
Pretty much all later. So before college, I'd gone to India to visit my extended family. And then I'd just taken I'd taken a church mission trip to Mexico. But that was pretty much it.
Yeah. So you in some sense, you had kind of grown up in a little bit of a bubble that you hadn't been outside of much.
Absolutely.
Yeah. And did you choose Grinnell sort of on purpose, knowing that it would be different, or did you just show up? I mean, I know, like, when I was picking a college, I really had no idea what I was getting into. Like, I applied to a few places, got into one, and was like, that sounds good, I'll go there. When you're 17 or 18 years old, you don't necessarily really know what you're doing. But like, how conscious a decision was that on your part to go to a place that was very different? It
was a pretty deliberate choice in some ways. I have always considered myself pretty progressive, and just being in an environment where there's a small group of friends that we maybe have the same views, but everyone else is different. I just wanted to experience some relief from that and see what it was like to be in a different setting, and also to be in a place that was more diverse in other ways.
So even when you were living in Nebraska, your politics were already sort of trending progressive?
Yeah.
Where did that come from?
My parents are pretty progressive people, and so I think it was largely from the way that they raised me and the values they raised me with.
All right, that's very interesting. So you get to Grinnell. What did you major in when you were at Grinnell?
I majored in religious studies and political science. I was a double major.
And at some point during your time in college, was that when you sort of made the decision to pursue law?
Yeah, toward the end, I really did love my religious studies major, and it wasn't like a theology degree, so it was studying various religions around the world. And one of my main focuses was the intersection of religion and politics, actually. But so I did still have some thought that I could maybe get an academic degree in religious studies, but I thought I did still want to be involved in politics and policy making and to make a difference on a large scale, and I thought I could most likely do that if I went to law school, and that's what made the logical next step for me.
And so you went to Duke University Law?
Yes. I did take a year off in between.
Were you doing anything particularly interesting that year, or was it just kind of like you needed a decompression year?
Yeah, so I did what's called a Watson Fellowship. There's a group of participating liberal arts colleges, and among them, 50 fellows are selected each year, and you do a project overseas. So mine was focused on the Indian diaspora and cultural mixing in the Indian diaspora. And I'll give you just like a short summary, but basically in several countries in the world, after the abolition of slavery, particularly in the British Empire, they still needed cheap labor. So they invented basically a new form of slavery, which is indentured servitude, and they brought poor laborers from India into these countries. And I was most interested in how years on those populations interacted and mixed with other populations that were in those countries, including former slaves. So I traveled to primarily Fiji, Mauritius, Trinidad, and Guyana to study that issue right after college, which was a fun year. Those are good places, particularly, Fiji and Mauritius are good places to be as a 22-year-old.
No, that sounds like a fascinating year. So you hit 4 countries in 1 year. Did you have to, at the end, sort of produce some sort of academic piece or something?
It's kind of the beauty of the Watson. They really emphasize experiential learning. So they don't want you to produce a big written work. They say that you're the product, and after this, you're going to be somewhat transformed. So all they do is you get together with the other fellows at the end, and you do a presentation about what you did, and you have a few days where you just spent with the other fellows kind of decompressing and talking about your experiences.
That's amazing. That sounds like a fantastic thing.
Yeah, it was an incredible year.
Yeah,
absolutely.
And did anything that happened while you were doing that kind of change your view of what your future path was going to be?
Not necessarily. No. There were some interesting just stories and what you learn about the places, like interesting leaders. One of the places I visited along the way was South Africa, and just visiting all the sites in South Africa and learning about both, Gandhi and Mandela and all the great leaders there, and how they were able to, in many ways, transform a society in a relatively short period of time. That's all inspirational, and again, in line with my hopes for my career, which is to help shape for the better the lives of many people.
Yeah. No, that's great. All right. So then after that, you go to Duke Law, and just to kind of place this in time. So you graduated from Grinnell in 2006, right?
Yes.
And then you graduated from Duke Law 2010.
Yes.
And somewhere along the way, did you sort of discover litigation and decide that that's what you wanted to do?
Yeah, one of the formative experiences I had, there were a few things. I'll say one thing first and then just mention a couple of professors who were influential.
Sure.
The summer after my 1L year, I went to India and I worked with an organization called the Self-Employed Women's Association, which is the largest union in India. And it primarily consists of women in what's called the informal sector. So a lot of street vendors, people like that who don't have formal employment, independent contractors, so to speak, as we would call them. And I worked on a piece of what's called public interest litigation, which is basically their equivalent to a class action on behalf of street vendors who had been unlawfully harassed by police officers and the city government as they were trying to kind of basically like gentrify or beautify their city. They were, strongly disrupting the lives of these workers. So I worked on that, and that was a very formative experience. And it's interesting because I went to India to learn about a mechanism that really is very American kind of in its nature, but got to see the direct impact of that, or the importance of it. And that led me along the path of, wow, this is the type of work that I would like to do when I'm back in the U.S.
And did I think you said that there were some professors at Duke that kind of influenced that path as well? Tell me a little bit about that.
Yeah, so my first year I had Erwin Cheminsky as a professor in constitutional law. He was still at Duke before moving to California. And he's just an amazing figure. He's both like an incredible teacher, but his values are also so strong. I mean, he told me and told the class once about when he was a young attorney, his first job was at DOJ, and they gave him a file and said, hey, you need to help prosecute this person in the military who's being discharged for being gay. And he just told them, no, I'm not doing that. And I thought that was, really admirable and showed a lot of integrity on his part, that this is, his livelihood, and he's risking it just to say, I'm not going to do anything that goes against my core values like this. And so both him and his wife, Catherine Fisk, who she taught civil procedure and did some, we even got some exposure to class actions there. They were both great professors, and particularly their values and emphasizing that, hey, you don't need to go. So one, I'll just briefly mention this, but one event that Erwin Cheminsky would put on every year was, you don't have to join a big law firm. And it was just telling students, like, look, there's so much pressure to do on-campus interviewing with big defense firms. You don't have to do that. You could go to another type of firm. You could do other types of work. And that I thought was a really important message to hear, because everything else that I was hearing both from other students and everyone else is, hey, just go to a big firm, pay off your debt, see what happens. Right.
Yeah. And certainly at a school like Duke or sort of other kind of name brand law schools, that is definitely what happens. It's just really sort of easy to get a job working for a large corporate law firm. They basically come to those schools and offer you jobs without really that much effort on your part, right?
Exactly.
And the schools kind of set things up to make it easy as well in terms of like what the placement office does. But for students who want to go on a different path coming out of law school, it can be a little more challenging. So it's interesting to hear that there was a professor there actually literally saying, hey, there are other paths that you can take coming out of law school. I mean, I went to Columbia Law School, where something like 90+% of people coming out of the law school went to big law firms.
Yeah.
Which was at the high end, I think, compared to other schools, probably because we were in New York. But that was definitely true. I mean, there was like a small public interest community, students who were interested in doing public interest law, but that was often very focused on, sort of more the nonprofit sector, the advocacy sector, not so much small law firms. Small law firms were kind of invisible when I was in law school.
Absolutely. That was the same for me, except for this event that Professor Cheminsky did.
Yeah. And so after law school, you ended up going to sort of a smaller law firm, right?
Yeah.
So tell me kind of how that came to pass.
Sure. So I told the career office, I said, look, this is the type of work I want to do. I want to be a plaintiff side class action lawyer. I'd figured it out by then. And I'd summered in at another firm in DC that did similar types of work as that. And they said, okay, we have some alums you should reach out to. So one of them was Gary Mason, was a Duke Law alum, and he has an office, at the time had an office at DuPont. So I just basically rang him up and said, could I come work for you? Here's my resume. And I came and interviewed, and Duke has a great program called Bridge to Practice, where they will pay the employer for your first 8 weeks of employment. Basically, they'll pay, I guess they'll pay the student as sort of a trial run. And so I did the Bridge to Practice program with Gary's office, and it worked out well. We worked well together, so he made me a full-time offer.
Yeah, no, that's fantastic. So looking back on it, do you think Duke was a good place to go to law school for somebody with sort of the similar career interests that you had?
Yeah, it's hard to say. I guess it's sort of what you said about Columbia. It's the picture isn't necessarily that they gear you toward that work, but everything worked out for me. And so I would just encourage people, if you have these sorts of values wherever you are, whether you're at Duke or Columbia, just seek out opportunities to do this type of work. And I had tremendous professors. I had a good experience at the career office at Duke, so I can certainly say that.
Okay, well,
yeah.
That's good. That's good to hear. So you were at Gary Mason's firm for about 6 years, right?
Yes.
So that was roughly 2010 to 2016. And we'll sort of come back to what happened in 2016. Mm-hmm. But while you were at that firm, you were also doing some academic writing, and we're going to be talking about some of that. And that's a little unusual for a practicing lawyer to also be sort of writing these very kind of long, detailed academic pieces that get written in the legal world. It's certainly probably time challenging to do both. So, just totally putting aside the substance of what those articles were about, which we will definitely get to, like what inspired you to kind of take on those projects?
So at Duke, one of my other good experiences, probably one of the best experiences, was being on Law Review. And I was an articles editor. And an articles editor's job is to basically evaluate incoming articles to see which ones you should float to the other publication team to get published. And so I read just a ton of Law Review articles. And then from that point, I would edit them with others and shepherd them through the publication process. So all of that, I had such a strong interest in the writing. And I, had that academic bent both at my undergrad too. And so I wanted to keep up that interest even as I became a practicing lawyer. And as you said, particularly as a junior lawyer, you're still kind of learning the ropes. It can be difficult to both do that and write academically. So there'd be mornings I'd wake up at 5 a.m. to research and write, or stay late at the office, both, after I did my work than just to do my personal academic work afterwards. So it is difficult to find the time, but I found it rewarding.
Yeah, that's great. And just for listeners who might not have gone through law school, just to kind of explain what Jason meant when he said that he was on Law Review. So one of the unique things about the legal profession is that most academic legal writing gets published in what are called law reviews, which are periodicals that are published by the law schools. But those journals are largely run and staffed by law students who act as the editors of the pieces before they're published. And at most law schools, there may be more than one law review. Usually, there's sort of a flagship review of each school. So does Duke have something like the Duke Law Review?
Right, the Duke Law Journal.
The Duke Law Journal. Yeah. So that's sort of the flagship one. And then sometimes there's also some more topic-specific ones that are run by the schools. But and then there's often some sort of process where the first-year law students are kind of sorted into these journals to act as editors for the different journals. So that's what Jason was talking about being on Law Review. So you got exposed to kind of legal academic writing by sort of playing that role as a law student on the journal, right?
Absolutely. One of the beauties of the system that I appreciate is that it makes the academic writing accessible, because ultimately you're pitching it to students as a professor. And so it can't be so esoteric that the student has no idea what's going on. So you'll see a lot of times the beginning of law review articles are situating that piece within the broader literature, which I find very helpful, because you can kind of just jump into a law review and immediately get oriented into, wow, how does this place into a deeper conversation, which I don't think is true for other disciplines necessarily.
And so did you have ambitions of maybe getting back into academia as a professor?
I did, yeah.
Is that still something in the back of your mind, or have you given that up?
No, I would like to potentially, I don't think as a full-time professor, but, just continue to do the academic writing and potentially, research and maybe be an instructor in some capacity as well. I had another good professor in law school because I was starting to send my resumes also to places to be a teacher, which is, very difficult in the job market. But what he told me was, he's like, look, I think you could go get a clerkship. You could become a professor somewhere eventually, but why don't you give practice a shot and see what it's like as well? And I'm really glad he told me to do that because I had sort of envisioned myself as maybe I'm, too academic and I wouldn't do well as a advocate. But he reassured me in that way, and that was helpful.
Yeah, there is a bit of a division in the law world between sort of academic lawyers and practicing lawyers, and sort of what they do and the types of issues that they're focused on can sometimes feel like they're almost two completely different worlds. I mean, I've had the experience of just like picking up an edition of a law review and kind of flipping through the articles and being like, there's nothing in here that a practicing lawyer would have any interest in. Right. They're all. It's like the academic legal world is almost like its own little hermetically sealed world. But there are a few people like your professor at Duke, who try to bridge that world, who try to either write academic work that is more geared towards the real world, practicing lawyers, or who at least try to keep a foot in both worlds.
Definitely. I edited one article by there's a professor named Adam Zimmerman who still does a lot of work in the realm of class actions. And that article was about applying the principles of behavioral economics to class action notice programs. Like, how do you get consumers to pay better attention to notices? And I thought that's a very practical and useful thing for lawyers to know.
Yeah, absolutely. So, all right. So just to kind of like round out the story of your legal practice. So something happened at the beginning of 2016. So after you were at Whitfield, Bryson and Mason for about 6 years, what did you do next?
So Nick Migliaccio was a partner at Whitfield, Bryson and Mason, and him and I spun off to start our own practice in the city. Our own class action practice, doing similar types of work as we were doing at Whitfield, Bryson, Mason. So primarily consumer protection, wage theft, civil rights, those types of class actions.
And what made you want to leave and start your own firm?
I think the idea of just being able to pick your own cases, litigate your own cases, be your own boss. I think really all of the reasons people say that they want to start their own shop were true of me and Nick.
And when you started, was it literally just the two of you?
Yeah. Yes.
Yeah. Well, that's
better and worse.
That's how we started our firm. You got to start with somewhere, right? And so you're now in about year 5 of that project. Is that right?
Yeah.
And how's it been going?
It's been great. Yeah. I've really enjoyed it.
Yeah,
absolutely.
Okay. Well, that's great. That's great. And so tell me, maybe just give me some examples of like, just so the listeners can kind of get a feel for what your practice is of, maybe some interesting cases you've worked on since you started your own firm.
Sure. So there's one case that our firms have together against this company, Libre by Nexus, which is a middleman basically for bond companies. And they assert that they assist detainees in getting out of detention. So someone's placed in immigrant detention, they get they have to post a certain amount of bond, and this company comes in and says we can do that. And their business model was then they would put on a GPS device to these people and they would charge them $420 a month kind of until eternity, which was a lot for them. And also there were some serious issues with the devices. They would overheat. They would need to be charged for long periods. So it's kind of Orwellian that someone could be literally tethered to a wall for 2 to 3 hours. And, we litigated that case, and it ultimately culminated into a class action settlement. We're still trying to get them to comply with all the terms, but that was a particularly rewarding case. I remember one of the named plaintiffs she was pregnant, and in order to make her payments, she would be skimping on meals at the grocery store to like save up enough money, or one of the others would literally collect cans for recycling to try and get enough money. And so just like being able to represent plaintiffs like that, and to pretty early they took off both of their monitors, and even just that act of helping the named plaintiffs do that was tremendously rewarding. And then also later in the case, they agreed to move away entirely from ankle monitors, so no one is subjected to this practice. So that was a very rewarding type of case.
And so this is sort of an example of what you call aggregate litigation in the academic pieces we're going to talk about in a little bit. But this is a company that had a particular product and a particular service. It was affecting, I don't know, thousands of people.
Yeah, thousands.
And through bringing just a single lawsuit, you're able to affect some sort of change or get some sort of relief for a large number of people that are affected by that practice without all of the individuals needing to bring their own lawsuit, right?
Exactly.
And that's basically the high level understanding of what a class action is in the United States.
All right.
Yeah. And so it's important to kind of have that basic understanding. So let's, to understand the kind of the topic we're going to dive into. So let's kind of shift to that. Mm-hmm. I did a little kind of digging around getting ready for this interview into kind of just the world of U.S. foreign aid. And so I think maybe to sort of set the table for the discussion we're going to have, let me just say a few things about that for the listeners. So what we're going to be talking about is the idea of legal reform strings that are attached to investments that are made in what are often called emerging markets or developing countries by the United States, either directly or sometimes through multilateral organizations like the World Bank or the International Monetary Fund. And I think sometimes people have like the wrong impression about what foreign aid really means. It's a term that gets bandied about sometimes in the political realm and during elections and things like that. And sometimes this idea of foreign aid is kind of vilified in the press or by certain politicians. So here's just some like basic facts about what U.S. foreign aid is that I was able to glean. So the U.S. government spends, in recent years at least, somewhere between $40 and $50 billion per year on what they call foreign aid. That's a lot of money, but it's a very small percentage of the federal budget, about 1% or less than 1%. The U.S. provides more money in foreign aid than any other country in the world by an order of magnitude, but a lower percentage of our GNP goes to foreign aid than a lot of other kind of wealthy Western countries. So depending on how you look at it, we either do a lot or maybe we don't do a lot. I don't know. And foreign aid has within it sort of two major components. There's foreign aid that is primarily about military and security issues. And then there's foreign aid that is more economic development. About 33% of our what we call foreign aid dollars really is military money. And then about 42% of that is what we call development aid. And then the rest is some mix of at least what the U.S. government characterizes as either humanitarian or political aid. Not really sure where the borders are between those different categories, but that's kind of the rough breakdown. The sort of development aid is dispersed to more than 200 countries around the world, mostly in Africa, the Middle East, and South and Central Asia. And I just say for anybody who's interested in kind of digging into these numbers and actually seeing data about U.S. foreign aid, there's a great website that I think is run by USAID, but you can look at foreignassistance.gov, foreignassistance.gov, and there's just a lot of great data there that shows exactly how much money we're spending, what countries it's going to, what programs they're supporting. So I thought that was really interesting to look at. But that's a little bit of the background. So that's at a high level description of where U.S. dollars are going in foreign aid. But what we're going to talk about is one sort of narrow but important aspect of that, which is the use of those foreign aid dollars to try to affect legal reforms in the countries that we're sending foreign aid to. So let me just start with this question. How did you get interested in this topic?
I've always been interested in international development from my time in undergrad forward. And so I don't know ultimately where that sprang from, other than just kind of compassion for the well-being of others more generally, and how the U.S. could provide assistance in that realm.
Okay. And so you decided at some point to really dive into this and do some analysis of kind of how it is that we try to affect legal reforms in other countries, right?
Yeah. And, one major component of aid is something called rule of law aid. And it's for a long time, it's been in vogue as a non-controversial form. Who can disagree with rule of law? I think The Economist once said it's the mom and apple pie of foreign aid. So everybody could get on board with that. And I was interested in sort of interrogating what that concept meant.
Okay, so what does rule of law aid mean?
It's sort of what you said about really affecting change into foreign countries' legal systems. And one way that it's been conceived, and primarily how it's worked, is to reshape their economies to accommodate a free market system, basically, to establish certain rules about property, contract, and in the realm of economics, so that a free market system could thrive.
And you mentioned something in your article, and maybe we should just say that the name of the article that you wrote about this topic, in case people want to go look at it, read it. The article is titled "Emerging Markets, Vanishing Accountability: How Populations in Poor Countries Can Use Aggregate Litigation to Vindicate Their Rights." And what journal was that published in?
I believe it's called the Transnational Journal of Contemporary Problems. Okay. I think that's what it's been a while.
Yeah. All right. So you can look that up. Jason is the author of that article. And so you talk in that article, sort of the setup part of that article, about kind of a little bit of the history of kind of how we got to this idea of rule of law and what it really means. And maybe you can just kind of walk us through a little bit of that to kind of set the table for this discussion about aggregate litigation.
Yeah, a lot of it emerges in, I believe it's the 50s and 60s, under the umbrella of a different term, which was law and development assistance. And that emerges in the Cold War. And the U.S. is trying to set up a bunch of foreign countries to have market-friendly regimes. So when we think about that, we think about places like Chile, where a bunch of University of Chicago students go and help set up a free market system. They're called the Chicago Boys. And this happens across a lot of places in Latin America and other parts of the world. And that's kind of the grandfather of today's rule of law aid.
And was that sort of law and development project generally seen as successful or not successful, and why?
Generally seen as unsuccessful, that it didn't, in some of these countries, in Chile, they do transform into a free market system, but it's not through legal assistance. It was more kind of illegal assistance in the case of Chile, where there was a coup that installed a market-friendly leader backed by the U.S., and that kind of happens in other places across the world. But in terms of the transforming their native legal systems through these means of sending U.S.-based lawyers to help train people, it doesn't organically work in the way that they hoped. And today, the legal scholarship is primarily that, this didn't take because there was a cultural incompatibility between the U.S. legal system and foreign legal systems, which I think has some truth to it. Anytime you're trying to translate a concept from one place to another, it might not necessarily take, but I think that that's missing another key ingredient, which was just that the populations of these countries may not have wanted to do that. And so they resisted the idea of, why should we transform our legal systems to accommodate a free market? And it was there could be more economic reasons for their resistance and why these ideas didn't take off as hoped by the marketers of rule of law aid or law and development aid.
And so sometime, I think you say like in the late 70s or maybe into the 1980s, this idea of rule of law emerges, sort of a new name, but sort of the same basic idea.
Yeah, exactly.
And was it always sort of tied to foreign aid? In other words, was the mechanism for trying to change the legal systems of other countries to effectively like offer a carrot? In other words, what is the mechanism, like, to the extent like how does this actually work, like at the mechanism level?
Yeah, I think later, like in the 80s and onward, and potentially a little bit before, we see more of this tying aid to, if we give you aid, there's strings attached. You have to implement this set of rules. And the IMF kind of becomes notorious in some circles in the 80s for something called structural adjustment, where they say, okay, we're going to give you aid, but you've got to reduce expenditures in these areas, which were important areas like education or housing, because in order to fix your system. And part of that becomes you have to accept this rule of law aid, and you have to make certain changes to your legal systems as a string attached, which I don't think that was necessarily as much a part of the law and development as it becomes part of the rule of law aid in the 80s onward.
And you make the point in your article that the sort of the legal changes that were being pushed under this rule of law umbrella were not neutral. In other words, what was being pushed here was not necessarily just sort of the rule of any law. It was the rule of particular laws, right? Yeah,
absolutely. So when you think of rule of law and why it gets such a large consensus is in anybody's head, they think, I love the rule of law. This sounds great. Why would I want, mercenaries or some other type of system besides rule of law? But it did mean a particular set of like a particular economic system and creating rules about contract and property to allow a free market system. It didn't mean other types of rule of what could be considered rule of law aid.
Yeah. And so maybe just give us some sense of like, what are sort of the key components then of that type of rule of law? What were the legal reforms that were being pushed, or maybe we're still pushing them? It's still going on, right?
Right. I think in broad senses, it's having a system where if your contractual rights are violated as a company, you're able to enforce that more easily against another company or against an individual. If someone owes you a debt, you could enforce that against them. Certain impersonal property rights that might not have been native to these systems. Basic types of things that would kind of enable business to business litigation or business to consumer, like in the case of debt collection, or if you think about like foreclosures or that type of thing.
And why, from your perspective, was it that those were the particular legal rules that were being pushed?
Even after as the Cold War was approaching, and I think there's just this sort of idea that the best economic system from the U.S.'s standpoint is a free market system. And so we want these countries to have that system. And that'll also put them in our orbit. I think that is a main driver, that they become an ally if they... And also then there's space for multinational corporations that are based in the U.S. to have a presence there as well. I think those are primary drivers of it.
And was there, I think for a lot of people, there is a sort of a tie between capitalism and democracy, that these two things sort of go together. Was that part of the thinking here, that in order to sort of encourage other countries to adopt political systems that were similar to ours, they also needed to have an economic system that was similar to ours?
Yeah, I think among some actors, that's certainly true. So there could be people at the State Department or at USAID who believe that, or academics. I think from the perspective of some multinational corporations and leaders, I don't know if they particularly have a preference as much as they wanted the economic system in place. So they may not think in that same way about it. And so a good example is Chile, where, they staged a coup, and this happens in a lot of Latin American countries where multinational companies that have a presence help facilitate or execute a coup in these places to install a market-friendly government, because that's really their ultimate goal, even if they're doing it by undertaking the ultimate undemocratic action.
I guess, one reaction I might have to that is, well, there is a inherent tension between respect for property rights, which I think is sort of, maybe if you boiled it down to one thing, right, you would say that's what this rule of law project is about. It's about having legal systems that respect, property rights, and because that's important to capitalism, that you have legal rights and property rights that are going to be consistent, that aren't going to change over time, that aren't going to be taken away from you by the government, and that you're going to be able to enforce, right? But there is sort of an inherent tension in my mind between having sort of stable property rights and having a dictatorial government, though, because a dictatorial government can just change the rules almost at whim, right?
Right.
So what is this connection then between sort of what you're calling sort of a business-led coup,
right,
and the rule of law project? It to me, just to play devil's advocate, it seems inconsistent.
Right. It was basically using different tools from the perspective of multinational companies or people that want market-friendly governments. There's one way to do it. It might be a coup, but then even in the wake of a coup, you need a legal system that's going to allow the market system to continue to work. You have to lay that foundation. And if you don't do a coup, if you try to just kind of backdoor into it, you could possibly do it through rule of law aid. But in your statement, I think there's also like kind of a point about what may have like preceded the coup, particularly so the U.S. was scared a lot of foreign countries, particularly in Latin America, nationalizing industry, which you have an oil company or somebody, and then the country says, "Hey, this is ours." And I think it's a good question about whether that's, I don't know, I probably disagree with a lot of people, but maybe that's democratic or anti-democratic in some sense. So it's not respect for the property right of that oil company necessarily, but how did that oil company come to have the resources it has? And is the goal of the nationalization to bring the distribution of that resource under democratic control? So you have a democratic system, someone is elected, they nationalize an industry, and now they say, okay, as a people, we're going to decide what happens to this industry. I think that's in some ways more democratic.
Yeah, and you could make an argument that, at least at a high level of abstraction, that is not necessarily a violation of the rule of law if that process occurred pursuant to whatever the laws of that country are, right?
Right.
That's actually that could be a more lawful process than a military coup.
Right, absolutely.
Which is often kind of extra legal.
Exactly.
Right? But again, that's not how the term rule of law is actually used in this space, right?
Right, for sure.
So you in the article you mentioned something called the Washington Consensus, which you say was sort of summarize this like policy perspective that was behind these rule of law projects. Could you maybe kind of explain a little bit about what that means and where it came from? Yeah,
it's similar in concept to what we've been talking about. It's just this sort of like bundle of reforms that people in the U.S. thought foreign countries should adopt. So, there should be personal property rights. We should allow capital markets to thrive in these places, and we need to lay the legal foundation for it. We need to, if that means engage in what the IMF calls structural adjustment. So these countries, in order to achieve these things, they need to scale back their expenditures in health and education and a whole lot of other realms. Then that's what they need to do. So that's more or less what the Washington Consensus was in the 80s.
All right. So let's kind of move into a little bit of what your sort of critique of this is. What do you see as the potential problems with this rule of law project?
Yes, I think the biggest problem is we have all of this aid, the U.S., but also through, as you mentioned, the multilateral institutions, IMF, World Bank, going into these countries. And then particularly after the end of the Cold War, now we have a whole bunch of Eastern European countries that are coming into the fold where this aid is going in. Also a lot of aid from actors like George Soros and his foundations. And that's allowing free market reforms to thrive. And this enables multinational companies to come in and have a strong presence in these places. But with that market thriving, inevitably there's going to be defective products, there's going to be wage theft, there's going to be all sorts of externalities that come with that. And so with the rule of law aid that we're fueling that lays the groundwork for this, there's not an accompanying rule of law aid to hold multinational corporations accountable for what bad acts they may commit there. Unlike in the U.S., where we do have that, we do have free market system, but we also have a system to try and hold those actors accountable when they commit bad acts.
So basically what you're saying is we were only exporting like half of the puzzle.
Exactly.
We were exporting the half of the puzzle that sort of allowed the creation of large capitalist markets that big companies could operate in, but we weren't exporting the part of the legal system that was intended to deal with the consequences of that.
Absolutely.
Yeah. Many of which are very good, but some of which are not so good, right?
Right.
I mean, this is sort of the two sides of the capitalism coin. I mean, it has both good things and bad things to it. And at least in the United States, we have a legal system that both allows capitalism, but then also provides various mechanisms for dealing with the, potentially negative consequences of that, like, widespread distribution of a defective product. Let's just give that as an example, right?
Exactly. And one of the interesting things I mentioned in the article is that sometimes in the U.S. there'll be a defective product and it'll get banned in the U.S. or there'll be a class action about it. Mm-hmm. And the companies will just sort of retool it and be like, okay, let's just dump this into emerging markets now, where they know it's a defective product, but now they're just going to put it into a foreign country. It's pretty nefarious. There's no similar mechanism to hold them accountable there.
Right. So what is your proposal then for kind of fixing that problem?
So the proposal I pitch in the article is that these countries should develop aggregate litigation systems. They should develop a system of private enforcement in which individuals could step forward, organizations could step forward and say, I've been harmed by this practice, and so have a large group of others, and we have the right to petition the government or judge to hold this company accountable for what it did.
And is that what you have in mind there as the model, at least, sort of, is the U.S. class action system, right?
That's correct. Yeah.
And do other countries around the world have systems like that?
They do. So not nearly to the extent as the U.S. The U.S. is still fairly distinctive in this system, which was brought about by, changes to the federal rules in 1966. But after that, some other countries did start to adopt it. So Quebec in 1978 in Canada, they adopted a pretty similar class action system. And what's interesting there is Quebec is a civil law country, so a very different legal culture, but they basically import the same concept. It sits dormant for some years. But
I'm not sure Quebec is a country yet.
No, fair enough. Yeah, exactly.
People in Vancouver wouldn't like to hear you say that, but
sorry to use your podcast to start an international war here. But yeah, sorry, I misspoke. So Quebec as a province had developed the system, and they have a civil law system, and it sat dormant for a number of years, but then did pick up steam, and it got used and continues to be used today. Also, and then that sort of laid the groundwork for Ontario, which is where Toronto is, to adopt a similar system. And recently, Canada as a country as a whole has adopted in their federal system. So there's Canada, but there's also places, other places in Europe, and then even some poor countries. So I mentioned India has this public interest litigation system. system. Brazil has a system. Chile has a system just for consumer protection claims.
And are any of those systems, like in Brazil or India or Chile, are they what is the sort of historical connection, if there's any, between the development of those systems in those countries and this rule of law project? I mean, were they tied, or were they just things that happened in parallel but were not connected to each other?
My sense is that they developed in parallel, but they're not directly connected. Or alternatively, that it could be connected insofar as there were these big problems that presented themselves, and this was a means by which to address them. It's similar, kind of like if you think about, so the U.S. has a qui tam provisions or whistleblower provisions, where someone who knows about a fraud can report it and get a portion of the proceeds. And that was really prominent early in the U.S. Republic because there wasn't a lot of law enforcement, or informers played an important role. And so it's sort of by the nature of scarcity. I'm speculating in these countries, but it could have been possible that, hey, this is one tool we could use to hold these companies accountable. And this is a model that's worked in the US. Why not bring it here as well?
Right. And so this is the idea that these different sort of forms of aggregate litigation are sort of an extension of the government's own enforcement mechanisms.
Absolutely.
Right? Because the government only has so many lawyers, they only have so many investigators, and often it's actually private citizens who are being affected by these practices, who are going to be the ones who are going to notice the problem long before the government in any official capacity notices the problem, right?
Absolutely.
Yeah. And so these, although the litigants are private litigants, these types of aggregate litigation systems can actually be seen as enforcement mechanisms.
Yes. And, to go back to one of your earlier questions about what is kind of my proposal, I do think having a thriving regulatory apparatus is obviously really important and a key ingredient in enforcement as well. But as you said, there's certain advantages of the private enforcement system, that you have a lot of people on the ground that can see the problem, whereas the government, particularly if it's strapped with resources, may not be able to identify and address it in the same manner.
If you had your druthers, if you could just design the U.S.'s foreign aid system, which way would you go? Would you just sort of get rid of the rule of law project, or would you keep it but sort of add something new to it, which is that, look, if we're going to export our legal system, let's include the parts of our legal system that are there to protect consumers and to protect workers? Which way would you go?
Yeah, it's a good question. So, I mean, if I were in charge of foreign aid, I'm more of a democratic socialist myself, so I probably would not support necessarily the export of these free market rules. I would support a different advocacy of a different type of system, not with the same kind of or certain coercive measures. But apart from that, let's say just if we're going to have rule of law aid, if we're going to be exporting in mass markets, then I do think it's incumbent upon us to also say you need to develop. We could help you develop systems of aggregate litigation along with a regulatory apparatus to hold these actors accountable when they do bad things.
Well, so let's back up then to that preceding question, the one that you kind of like skipped over there.
Yeah.
Which is, should the U.S. be in the business of exporting legal systems at all? Mm-hmm. I mean, it's one thing to just advocate, to say, right, hey, we've got a great legal system, or there's things about our legal systems that we think are really helpful. We think the rest of the world should adopt these same things, and to advocate for that. Mm-hmm. It's another thing to tie foreign aid to those changes, right? Because that could be seen as potentially coercive, in the sense that perhaps the recipient of that foreign aid really needs the money.
Right.
They're not really that interested in the legal reform side of it, but they will go along with it in order to get the money, right? That's the idea. So, like, should the U.S. be tying legal reforms to foreign aid at all?
Probably not. I don't think so. Just because of the coercive nature of it, it feels kind of neo-colonial is a term that is thrown around with it. You know, it's like you desperately need something. Let's say it's food aid, or you desperately need malaria nets. And you know, if you want those malaria nets, we're going to completely transform what your population wants to do. It doesn't feel right. And it feels somewhat undemocratic to kind of force this upon people. But the idea of exchange, and that, which I think is what has happened with the adoption of class action rules in the places that have done it, it doesn't feel like I don't think it's ever been the product of a coercive thing, but just to say, hey, this is a system that we have. Here are, you know, what are seen as the costs and benefits of it. You should really think about adopting it, particularly now as your economy is becoming more market oriented.
Mm-hmm. Yeah, and I think, as you've pointed out in a couple of the pieces you've written, one of the, you know, I don't know if ironies is the right word, but I'll use it. One of the ironies of the current situation is that as other countries around the world are starting to adopt more and more of these sort of aggregate litigation mechanisms that were really innovated in the United States, here in the United States, if anything, the trend has been to start to cut back on those, the availability of those systems. And, you know, so what do you see as accounting for those sort of two different trajectories?
I really think it's corporate power and the power of these multinational corporations that they wield in the United States for other reasons. And it's really picked up from the 1970s onward. So in the 70s, we see kind of a great spike in lobbying among the Chamber of Commerce, and a lot of companies start to develop PACs in DC. K Street gets filled around that time, and it's really kind of only accelerated since then. And with decisions like the Citizens United decision that allows basically unlimited expenditures by these companies in elections, there's more and more government capture, and as certain administrations appoint judges that are approved by K Street, that necessarily leads to a constricting of our private enforcement system here, unfortunately.
Yeah. And, you know, I think, I guess you could add gerrymandering to the list of problems that kind of leads to those concentrations of power as well.
Absolutely.
Because at least in my view, that contributes quite a bit to this problem of kind of the capture of politicians by special interest groups.
Definitely.
Which happens on both ends of the political spectrum, but definitely at least on the Republican side, that capture is often really, what we're really talking about is business interests.
Right.
Yeah.
Exactly.
And so when you have a Republican president, those business interests have a lot of say over the legal environment and over the appointment of judges, which becomes really important because, you know, as you and I both know, because we practice in this space, Rule 23, which is the federal rule of civil procedure that governs class actions in our country, the language of that rule hasn't really changed that much over the years. There's been little tinkering with it around the edges, but the actual law under Rule 23 has changed dramatically.
Yes.
Over the years in various ways, and the changes have generally been in the direction of restricting the types of cases that can be dealt with through this class action mechanism, and making it more difficult to succeed in those types of cases. Now, there's always going to be a balancing act there, right? I mean, you know, I'll be the first to admit that not every lawsuit has merit. Right. I think the argument that there's lots and lots of frivolous, meritless litigation is generally overblown, and nobody who practices in that space thinks that that's true, because, you know, as you and I both know, these cases are extremely difficult, extremely expensive, extremely time consuming. So the idea that people are just kind of bringing cases that they're likely to lose is a little crazy, I think.
Right.
None of us would be in business if we did that for very long. But certainly, you know, look, there's going to be arguments on the other side about that. But the balance of those arguments, at least, you know, maybe over the last 20 or 30 years, has definitely shifted, largely through judicial action, right? Again, this is not, there haven't, nobody's rewritten the rule. Congress hasn't passed, changes to the law. It's just that judges have, made decisions that have just made it harder and harder and harder over time to bring these kinds of cases.
Exactly.
Yeah. But it is interesting that as that's happening in the United States, these ideas are actually starting to gain traction in other countries. And, do you have some like sense of why that is? Is it just that like in a world where there is more free trade and, just more mass dispersion of products and more employees working for big companies, that just the types of problems that are dealt with in class actions are starting to become more apparent in other countries?
Yeah, I think so. I think that's certainly part of it. And when I think you see the same problem because of the dispersion internationally of products. So take, for example, the Volkswagen clean diesel scandal, where they installed defeat devices that fooled regulators. That was not just in the US or not just in certain countries, but it was all over the world that this happened. And it's interesting because there has actually been litigation basically all over the world. And the US, because our system in some certain areas still works quite well, the settlement was actually fantastic. I think in the US it was, people got buybacks. They got, I think on average, like $18,000. And when you see it in what happened in other countries' litigation, it's still working its way through their systems. But in Canada, the amounts that people got didn't approach that. But in Europe, there's been litigation seated all over. But I bring this example up to say that I think people could just see like, oh my God, like why were U.S. consumers so taken care of? But that didn't happen other places. And from a very visceral level, you're just like, that seems unfair. What did they do right that we're not doing right? And the EU, late last year, they'd been kind of sitting on this idea for a while, but they issued a directive to their member countries in the wake of the VW diesel scandal that said you do need to adopt class action rules for consumers in your countries, because there's also disparities within the EU about the remedies that people were receiving. So I think with mass markets, it's like the same problem that different places are experiencing, and they see the U.S. as a good example of, oh, wow, this, things worked out there. And it's just natural to be like, how could we make ourselves more like that?
Right. So, I think as is often the case, you get a very high profile case like that, and it sort of shines a light on the issue.
Exactly.
Yeah. And more frequently, those are issues that cross borders.
Right.
Yeah.
Definitely.
That's really interesting. So, let me just kind of bounce a couple other questions off you that I had, in reading your articles, just to kind of see what you think about these. I think people who favored the Rule of Law Project, or who favor it now, would say, look, when we go into developing countries, poorer countries, the sort of the first thing we need to do is to incentivize investment and growth. That's the key to kind of getting people out of poverty, raising standards of living, supporting democracy, so on and so forth. The list of all the good things that we want. That's sort of the simplest, most direct, fastest route to that, even if it has externalities, even if it has problems, is just to incentivize as much economic investment and growth as we can, as quickly as we can. And that if that is true, then it's actually right to do it the way we're doing, which is the first thing you got to do is get in place the rules, the legal rules that will facilitate that investment and growth. And then maybe down the road, we deal with the other problems. What would you say to that kind of argument?
I'd say that it's probably different for certain countries versus other countries that are starting from maybe a very poor place where they don't have many resources. But my general response would be that I think the answer isn't necessarily markets as much as it is development. So the country should be given space and potentially resources from the international community to develop their own industry, and also just to build infrastructure. So basic things like roads, bridges, all of that. And, places like South Korea, for example, they didn't immediately open up their markets internationally. They developed industries like, Samsung or Hyundai, Kia, and that grew over time. And through their own exercise of sovereignty, then they became a market participant later on very different terms, on more equal terms in some ways. So that would be more the approach that I would say, is that, they need this development, the ability to thrive on more equal terms. And you don't need to immediately give them kind of like a shock of U.S. pro-market rule of law in order to achieve that.
So another critique that someone might make, I think, of your suggestion has to do with just the nature of court systems in other countries. So, in the United States, we have a very sophisticated judiciary. We have an independent judiciary, and for the most part, it's a sort of a stable, well-funded, or at least consistently funded system. And so things like class actions, as you and I know, those are some of the more challenging types of litigation that the courts deal with. But we have a court system and a judiciary that's sort of able to deal with that. One might wonder whether in a poor developing country in some other part of the world, whether they have a court system that can easily adapt to the types of aggregate litigation you're dealing with. And the sort of the problems that I have in mind is that, in some countries, the court systems are not as independent as they are in the US. There might be, anything from political pressure all the way to outright corruption. Or in some countries, the judicial system may not be as well resourced. There may not be as many judges. The judges might not be as well trained. And so dealing with these types of huge cases may just be beyond their capacity. What would you say to those types of concerns?
I think one key criterion or hope would be that the judicial systems in other countries would be open and public. And I think if you have that baseline, then ultimately the reform should still work. So, and I'll say this for a few reasons. One is, you mentioned scarcity and capacity, which are certainly problems in these countries. But let's say that you're a judge in one of these countries and you're getting a bunch of cases on your docket and you're very far behind. There are a few ways that you could kind of work through your docket, one of which you could privilege the most, the cases that are the highest value. But the problem is that those might involve just business to business disputes, and it might not give really meaning to your legal system to adjudicate that, or they might not have significant precedential value. Another way could be you do the first file and you go through that way. And the problem with that, though, is that you could have some that, just are not big cases or not important for developing your country's legal system or culture. And I think this is where aggregate litigation could provide a useful role, in that they often involve adjudication of public rights. They're important to the public. And so if you see you're one of these judges you can only do so many cases, you see a class action case, maybe it's important to your legal system to do that, to have one, because it's a case that could be in the public eye, that people are paying attention to, and they could see, and it could help build kind of the impartiality of the legal system in the public's image. And so I think even if you have sort of a clogged docket problem, it could be useful in this way. Some of the other problems you mentioned, like bribery or the lack of a independent judiciary, so long as it's, in what I mentioned at the beginning, so long as it's public, and if it's a big case, like if the VW emissions case or something else, and the judge just gets bribed by VW, and they're like, okay, there's no case here, literally everywhere else in the world it's still being litigated. I think people in that country would be pretty upset by it, and it would really shine a light on that, and it could, even if you don't get immediate relief through the courts, it could create energy for reforms in that realm. And so I do think that these are problems, but that aggregate litigation could still work for the reasons I've set forth.
Yeah. And certainly, like, if we're talking about, foreign aid, I imagine that I don't know this to be true, but I imagine that in the places where we're trying to do this kind of rule of law foreign aid, that some of that money must go to just sort of basically developing their court systems. Because without that, none of the aspects of rule of law work. Right. Right. I mean,
exactly.
even if the only thing you want to protect is intellectual property rights, for example, you still need a court system that will enforce those rights and can deal with those types of cases, and those are not simple cases either. Sometimes,
exactly.
Yeah,
that's right.
I guess my take on it, despite my lead up to that question, I think I don't think there's anything inherent about these types of aggregate litigations that make them outside the capacity of courts in other countries to deal with. There's no particular reason for us to think that.
For sure.
One of the other points you made in one of your articles that I thought was interesting was that you say that aggregate litigation, in addition to sort of the obvious goals, which are get relief for the whatever the practice is, the victims of the practice, we're going to get some sort of relief, or we're going to stop the practice that we think is unlawful, that these types of litigations often have another function, which you call an expressive function. Maybe just say a few words about what you mean by that, because I thought that was a sort of an interesting concept.
Yeah, the expressive function is basically that by participating in this process itself, that has value, regardless of what the outcome is. So the person who's injured from the bad practice, by being a class representative, they are an active co-creator of justice. They're having to have their deposition taken. They have discovery. They're presenting their case to the public. In the case of a system with a jury trial, they're presenting it to their peers. And that process itself confers a certain amount of dignity and gives meaning to the judicial system. We have tons of stories in the U.S. that Hollywood movies based on, like a whole genre, or John Grisham based on these ideas. And a lot of them are rooted in aggregate litigation. When we think about how Big Tobacco was taken down, it was done by aggregate litigation. And that's, the expressive value is certainly an important ingredient. And one thing people may say is like, well, we only look at the value of it because it succeeded. We were able to take down Big Tobacco. But I think even in the instances when it's not successful, that tells us something too. And, just because something is unsuccessful in one generation doesn't mean it will be unsuccessful in the future. It could galvanize change. So Plessy v. Ferguson becomes Brown versus Board, or, we have a whole set of cases that could be considered an anti-canon, like Plessy, and those later become our canon. And this is, I think, an important ingredient in developing legal culture is to have this. I worked, as I mentioned before, on a public interest litigation in India for the Self-Employed Women's Association for street vendors. And there's a New York Times article about this issue, and they were talking to some of the street vendors who were involved, and they asked one of them, like, what has been the most important part of this for you? And she said, I now can like stand up and look a police officer in the eye when they're harassing me, and just stand up for my rights. So
it's almost like this idea of sort of truth and reconciliation commissions that countries have, right? That are almost intentionally designed to not be retributive or even to sort of involve compensation. They're just intended to purely become like almost like a safe space to tell stories about what happened in the country as a way of kind of like collectively moving on, or just collectively deciding kind of what do we do next.
Exactly.
Right. And so you're saying litigation can sort of serve a little bit of that purpose when it's done in the right way.
Absolutely. So even if the country did not have capacity at all, but at least people could come forward and memorialize the wrong that has happened to them. I think that's an important feature.
Yeah, and I think you could point to examples in the U.S. of where that's happened, even in the class action realm. I mean, sometimes class action litigation is kind of one piece of a much bigger puzzle. Right. I mean, certainly like in the VW example that you gave, yes, there was class action litigation, but there was a lot of other stuff going on around that issue. There was regulatory action, there was congressional hearings, there was a lot of other things going on. And the class litigation was the mechanism by which individual consumers could kind of tell their story and assert their rights. But that was only one piece of a much bigger kind of legal and political puzzle that was surrounding that issue.
Exactly. And that's another value of aggregate litigation, is even if nothing happens directly as a result, you're alerting potentially legislators or the public at large who might not know of something. It shines a spotlight on that issue and maybe allows them to marshal resources or to organize people to bring about change.
Yeah. And the other thing that I think that, maybe is not fully appreciated about the legal system is that if there are problems, particularly wide scale problems, like the kinds of things we're talking about, that don't have an avenue for redress through the legal system, it doesn't mean the problems go away, right? It just means that they find some other way of being dealt with, and in some sense, if you can take those issues and you can channel them through the legal system, at least you're dealing with them in a way that is open, that is nonviolent, that offers some hope for change, whereas if you just ignore those problems and don't give them an outlet, right, they will find an outlet somewhere else down the road. Yeah. And it may be an outlet that's actually less to your liking than the one you're going to get through litigation. Yeah,
that's a very good point. It operates as a safety valve in a lot of ways.
Yeah, and I think that's particularly true of the kinds of aggregate cases that you're talking about, where there's an issue that's affecting lots and lots of people all at once, right? Because the litigation gives those people a way to kind of sort of form a little community around that issue and assert their interests through the judicial system. And without that outlet, they might do it in some other way that's sort of extrajudicial or extra legal.
This discussion, it brings me back to a point we were talking about earlier about the U.S.'s system constricting or in some ways weakening, our private enforcement system weakening, in that if you think about arbitration clauses and the proliferation of them, it's basically taking huge swaths of cases outside of the realm of the public. And now, we can no longer bring those cases. Lots of people are no longer bringing those cases. Instead, they're kind of confined to a conference room and they're sealed off from the public. And so it's been a very unfortunate development that those agreements have been enforced, and that has taken away this tool from the U.S. public.
Yeah. But I think what's happening in the U.S. is that, that's an issue that folks like you and I have been aware of for decades now, right? This sort of slow creep of these arbitration clauses that then just exploded when commerce went on the internet, because now everything has a click-through agreement, right? You used to be able to just buy products at a store. There was no arbitration agreement. There was no way for the store to impose it on you. But now everything has an arbitration agreement tied to it, right? And so there's been this explosion of this problem. But what I've noticed, at least in recent years, is that this is a problem that is starting to actually enter into the public consciousness in a way that I don't think was there a decade ago. Yeah. You talk to people who are outside the legal world and they know what arbitration clauses are, and they understand what the problem is. Yeah. I think there's a pretty widespread understanding of that. And there have been attempts to try to pass some legislation or some regulations that have cut back on enforced arbitration. And my prediction is that that's going to increase over time.
I think so too. People are so, when you talk to clients on the phone, you tell them, they produced an arbitration agreement. They're so visibly upset, and you can understand why. They thought they had these rights. Yeah. They thought they could present to a jury their peers, and they had no idea buried in the fine print was something that deprived them of that.
Right. And this is kind of goes to my point about the judicial system being an outlet for people's expression of harm, if you will, that over time there will be enough people who have had their rights thwarted by one of these click-through arbitration agreements that you will just reach critical mass of people that realize that it's a problem and needs to change. And it's a problem that is completely apolitical, because the people who get screwed by arbitration clauses, excuse my French, come from across the political spectrum.
Definitely.
So I've talked to people who are politically quite conservative, but think that mandatory arbitration clauses are an absolute outrage.
Right, and un-American fundamentally.
Yeah. So I think the days of mandatory arbitration clauses, at least at the scale that we see them now, are numbered, although the number could still be quite high. Right. It could take us a long time to get there, but we'll get there eventually. I guess now is a good moment in the interview to also ask you if there are folks who would like to reach out to you to talk more about these issues, or just to contact you about anything. Like, what is the best way for people to find you?
Yeah, I think they could just email me at jrathod, RATHOD, at classlawdc.com. So that's my firm email address. I'd be happy to hear from folks and engage them as well.
Are you a Twitter user?
I am, yeah. So I'm on Twitter. I have a locked account, but people can follow me and I'll let them through. Yeah.
What's your Twitter handle?
So it's Jason Rathod. It's just my name.
Okay, fantastic. Yeah. Fantastic. All right. So we're gonna do what we normally do in these podcasts and just spend a few minutes at the end talking about something a little more personal, a little more lighthearted. We spent a lot of time talking about kind of deep, heavy political issues, so it's nice to end with something a little different. And when I asked you what you would like to talk about, you said, "Well, I'm a really well-traveled guy. I think you've been to how many countries?"
I forget exactly, but around 30.
Around 30 countries, and I think you also said that all of those places are outside of the places that Americans normally travel to. It's just like France, England. You've never been to Western Europe.
Exactly.
Well, you should go. There's some nice places there.
I definitely want to go.
I mean, Northern Italy is beautiful. You should definitely go there, check it out. But what parts of the world have you traveled to?
So I've been to, as I mentioned, all those countries in the Watson Fellowship. I've been to, recently, some places in South America, so Chile, Bolivia, Peru. Also, I really enjoy Eastern Europe too. So I've been to places like Romania, Bulgaria, places that many people go to, but are beautiful.
The parts countries. Of Eastern European that a little more off the usual travel map. Right?
Definitely, yeah. Greece. Morocco. Yeah, there's a whole
Greece
lot
counts as Western Europe.
Yeah, that's true.
So I would say you can't say you've never been to Western Europe.
Right. I don't know. These days, people may not consider that, but
yeah, it's an EU country, I think.
There you go. Yeah, I've certainly been to some EU countries. Maybe I'm parsing it a little too finely to say I've never been to the EU, Western Europe.
But I mean, there are parts of Greece that are still feel like they're outside of the rest of Europe.
Right. Yeah. Definitely.
Yeah. And so I think, and then you told me when you got married. So when was that?
This is 2015.
2015. Yeah. So when you got married in 2015, you decided to sort of mix wedding and more travel. So tell me a little bit about what you and your wife did.
Yeah. So my wife and I, Sheethal, we decided that we wanted to do a destination wedding. We really enjoy traveling. So we selected Cartagena, Colombia. We'd never been before, and we planned it all remotely. We didn't set foot in the country until a week before the wedding. And she is from India, and as are my parents, and they're actually both from the same part of India. So we decided to do some elements of a traditional Indian wedding in Cartagena. And I'm actually Christian and she is Hindu. So we didn't do a fully traditional Hindu wedding, but we did have the procession, which often precedes an Indian wedding. So she was already at the venue, which is a church, and her family and friends all were, and we processed from elsewhere in central Old City Cartagena through the streets with drums and instruments, and my whole family and group of friends. And I was actually, there was a horse, and I was on the carriage of it, dancing pretty vibrantly as we walked through.
And so, how long was this procession? Like, how many miles did you process?
I wouldn't say miles. I would say. Yeah, more. It was about I remember it to be about 10 minutes, so it wasn't too intense, but yeah, it was a long time to dance.
And do you need to? You're just sort of marching through a public street.
Yes. Yeah.
Did you have to get permission from the local government to do that, or was this kind of like a flash mob? You just showed up and started doing it.
More or less, just showed up and started.
there much of an Indian population in Colombia?
No, there isn't too much. We did manage to find a good Indian restaurant that helped cater food, but yeah, there is not much of a Indian population at all.
So this was something that the population of that city probably had not seen before.
No, my guess is probably not. Yeah, they were intrigued by it, a lot of them, and they came out. There's kind of like row houses in the old city where people came out and like looked out from the windows, and there's some people kind of perched on. There's like an old seawall that were watching it all go on as well. So I think they were pretty interested.
Do you think they understood what they were seeing?
I think so. Yeah.
What makes you think that they understood?
I don't know. I think we were all in like garb that suggested sort of a formal occasion. So I don't know. I'm not sure what else they could have deduced. But yeah.
Like who are these crazy people just like dancing through our city for no apparent reason? Right?
Exactly. Yeah. One of the funnier moments was that I think there were some, not in our group, some other Western tourists who we had the idea that I think they must have thought this may be a traditional Colombian wedding potentially.
Right. But sort of the reaction you got from the local populace was mostly positive.
Yeah, I'd say so.
And I asked you this question offline, but I'll ask it again now because I think it's just sort of an interesting question. Like, so you're in this city where you've never been before, and it's not your native country, and you're engaged in a kind of a ritual that is very public, but is foreign to that particular culture. Like, while you're going through that process, like what is sort of the psychological state that you're in? Because I could imagine, it's your wedding, you're having some fun, there's some positive things going on, but I could also imagine having a little bit of apprehension, like not really knowing, like, how is this going to go? Like, what kind of reaction am I going to get? What are these people thinking about me as I do this? Yeah.
I think there's just certain moments in your life where, you kind of have to step up to the occasion. We planned to do this. So I just felt euphoric and really, really into it and had adrenaline pumping and knew that I've got to lean into this experience. So I was, had a little bit of apprehension in the back of my mind, but I thought, who doesn't like a good party processing through the streets, right?
Yeah. Maybe it made it more exciting. Maybe it would have been less exciting doing it, in DC or something like that, where maybe people would have been more blasé about it.
Right. Exactly.
Yeah. You were kind of putting on a show for the local population in addition to getting married. For sure. Yeah. And so the wedding went okay?
It went great. Yeah. It was a fantastic occasion.
And you're still married?
Yes.
So that's
have a second baby on the way. Just a few weeks here. Yeah.
Congratulations.
Thank
you. Well, that's a fun story, and hopefully will give all of our listeners courage to travel far and wide and to really sort of experience other cultures and not be afraid of them. I think sometimes as Americans, when we travel, we sort of travel with a little bit of apprehension, particularly when we go outside of Western Europe. You don't know what you don't know. But it sounds like you'd already had that experience of traveling a lot in South America and just traveling in general, which probably helped you deal psychologically with that situation.
Yeah, and as we talked about earlier, I grew up in a very different environment, having not really done that type of travel. Yeah. So you're never too old to do it.
Yeah,
but you could very much embrace it later in life.
Where are you going to go next?
That's a great question. With the pandemic, it does pose some problems, but also having two young kids. We still love travel though, so we're hoping to do it soon. It may be Western Europe. We've been around some other places.
If you could pick one place to go that you haven't been, where would you go?
I would like to see London and Paris. I know now, after we had this whole discussion of these are the places you may not want to try. Having been so many other places, I do really love great big cities, like New York or LA. And so I think going to places like Paris and London would be a good experience.
Yeah, no, those are fantastic cities, and there's a lot of interesting stuff to see and do there. So, well, that's great. Well, I think this is a good point to sort of wrap it up. So I'll say thank you for your time. Thank you for talking to me today. And this was a very interesting conversation.
Thank you. I really enjoyed it.
Thank you for listening to this episode of The Garrulous Gavel. If you enjoyed it, please subscribe wherever you listen to podcasts. You can always find us at garrulousgavel.com. If you'd like to send feedback or suggest a guest, please contact us at our email address, garrulousgavel@gmail.com, or on Twitter at garrulousgavel. Our cover art was created by artist and illustrator extraordinaire Joan Tico. Our theme music was written and performed by scientist and saxophonist extraordinaire Robert Tico, and our producer is the inimitable K.O. Myers of Particulate Media. See you next episode.